Says the court orders Mr. Biden's counsel, this is Abbe Lowell, to show cause.
And Mark Geragos, who just joined the case, the Midas Touch guy, one of the funders of Midas Touch, one of the worst assemblages of scumbags in the United States.
Failure to file a timely and satisfactory response will result in sanctions. You may withdraw your motion or amend your motion, but doing so will not obviate your clear obligation to respond to this order. Woo! Failure to file a timely and satisfactory response will result in sanctions. You may withdraw your motion or amend your motion, but doing so will not obviate your clear obligation to respond to this order. Hunter moved to dismiss this indictment, saying that David Weiss violates the same parts of the Constitution that Jack Smith and his appointment violated. Says the court orders Mr. Biden's counsel, this is Abbe Lowell, to show cause.
And Mark Geragos, who just joined the case, the Midas Touch guy, one of the funders of Midas Touch, one of the worst assemblages of scumbags in the United States. Ben Meiselas, he should be disbarred yesterday for all of his lies. But
interesting.
Geragos hired Ben and is behind Midas Touch. These are the people we're dealing with here. Geragos, Abbe Lowell, Christopher Mann, Angela McCullough, Tina Glandian, the attorney for Jesse Smollett, they're all being asked to show cause.
Ooh, so they all got busted. They're all coming down to the principal's office. This is not for something insignificant, okay? It says why sanctions should not be imposed for making false statements in the motion. All right, false statements, it's the legal nicety of saying lying. Why are you lying in our motion? You said this happened. It's not true. I know it's not true. So you need to come and explain why you lied to us and why you should not be sanctioned for that, right? This is mom calling you in and you're in big trouble. So the local rules of this court require compliance with the rules. Violation of professional responsibility rules may serve as a basis for discipline, striking of pleadings, imposition of other sanctions. And in support of this motion, so here, the rules say you're not allowed to obviously make false statements of facts. So don't do that. The rules are clear about it. This is something that lawyers take exams over just to make sure you understand the rules of professional conduct before you ever take a bar exam. You have to take another exam to make sure you're not a piece of work, supposedly. Then you actually pass the bar exam. You also have to pass character and fitness. They go back through your entire life, make sure that you've never gotten a speeding ticket that you haven't told them about. All this stuff, right? We can't lie. Not supposed to. Now, in support of his motion, Mr. Biden asserts, through his counsel, all these attorneys that Garrett just explained, asserts several times that special counsel Weiss brought no charges against Mr. Biden until after he received the special counsel title. And special counsel Weiss brought no charges, they write in the motion, so they're referencing Hunter's motion, saying he brought no charges in this investigation with his U.S. attorney position. But as special counsel, he initiated legal proceedings on both sides of the country against Mr. Biden in Delaware and in California, saying Mr. Weiss sought special counsel status before bringing any charges. But the judge, right, this is a federal judge, comes out and says, all right, look, these statements, however, are not true. And Mr. Biden's counsel knows they are not true. So in his role as U.S. attorney for the District of Delaware, Mr. Weiss did bring charges by information, including 2 of the misdemeanor offenses subsequently charged by indictment in this court. Then, and in an earlier motion before this court, Mr. Biden's counsel also recognized that Weiss brought criminal charges against Biden before the special counsel appointment again. And remember that this is true, and we covered it, and we were pretty much outraged that they just took David Weiss from this U.S. attorney who was like BFFs with the Biden family in Delaware, and they're just like, oh, we're just going to make you special counsel now. What? The same dude who was investigating the underlying thing is now going to just suddenly inherit this case, and you're going to say it's like now a new independent investigation just because you gave him the title of special counsel? So specifically, counsel acknowledged that U.S. attorney David Weiss, so defense counsel, filed 2 separate informations against Mr. Biden. One information charged, so you guys, the attorneys themselves are saying that he's been charged with a single count felony unlawful possession of a firearm, substance charge, and they charged Biden with the tax charges, which is all what happened originally. And so the judge is not happy, man. And when you see this language, the misstatements in this current motion are not trivial. Mr. Weiss's institution of charges against Biden in his capacity as U.S. attorney offers a meaningful distinction between this case in California and the non-binding district court decision in Florida, opposite side of the country. Totally different district, different state, different jurisdiction. It's not binding on this judge. And it's totally different anyway. anyways. But Mr. Biden's motion does not even engage with this distinction. Instead, counsel avoids the issue by misrepresenting the history of the proceedings. So they're lying about what happened, and then they're avoiding the bad stuff, right? So there's a duty of candor, which means you got to be open. You can't hide stuff behind the closed door. This court has little tolerance for lack of candor from counsel, all those attorneys. And you can see they're going through a bunch of case law saying that they've admonished a bunch of other people in other instances. And so this came out, counsel for Biden shall respond in writing to this order within 7 days. And so that response should be out and due. Failure to file a timely and satisfactory response will result in sanctions. You may withdraw your motion or amend your motion, but doing so will not obviate your clear obligation to respond to this order. Whoo! That's from Mark Scarcy, baby. And if you don't read a lot of legal documents, like, that judge is pissed, okay? Like, it may not come across as pissed, but that judge is pissed. So he should be, because they're liars, man. They know that this is not even close to the same thing.
The funny thing, everybody on the stream should realize that's nice and quick, right? It's a 4-pager. It's not a long order at all, put together well. And the funny thing is, this is an assumption. The second this came through the ECF, I think Lowell was surprised because he probably didn't even remember the lie. They've been trotting out this lie so much, Robert, over the past 6 months that in their gradation of lying, this is like at the bottom now. Meaning every single press conference that Lowell does, he says, oh, when Weiss didn't bring charges for 3 years, and then after he gets made special counsel, he brings them on the other side of the country. All of that is rhetoric. All of that is bullshit. And information that was announced June 20th, 2023, after the whistleblowers came forward. And I love that you brought up Weiss earlier. Some people on the stream may believe that I like Weiss or that I'm pro David Weiss. This is all a limited hangout. I'm not saying that the attorneys aren't going to work hard at the charges that they brought against Hunter. Our complaint is much deeper about the charges they brought against Hunter. Not that I think that Leo Wise doesn't want to beat Abbe Lowell for purposes of his own ego. I believe he does. But there's no money laundering and there's no FAR. And without those two things, it's a limited hangout. But going back to the lie, the caption of this episode is true, but I do want to add a quick addendum. They are misrepresenting what the district court opinion in SD, Florida does for the Central District of California, meaning it doesn't apply, right? It's not binding. It's one district court judge and they're appealing it. Obviously, I agree with it and I think they're going to win on appeal. But nevertheless, Scarcy does make a point that they don't even address that. He does not engage with this distinction. Instead, counsel avoids the issue by misrepresenting the history. They do lie about the applicability. They are literally comparing apples and oranges. What does this mean? Weiss was appointed by the president, confirmed by the U.S. Senate. Jack Smith was not. They pulled him out of the Hague with his hagiographer leftist wife who wants to be a brown noser to Michelle Obama for the rest of her professional career. Totally incomparable. However, the order that they're wanting the attorneys to show cause on is just about their statement that Weiss didn't charge Hunter until he was made special counsel. Meaning Scarcy isn't wanting them to show cause about the apples and oranges. It's just that their response to this, I'm not sure if it warrants a whole other episode, to be frank, but the response to this order came about 72 hours later from Geragos and Lowell that said that it's just a single word, that we were inartful about a single word. They're going to change the word charges to indictments because, as you know, but maybe not all of your listeners, indictment is not the same thing as an information. No grand jury in June of 2023 indicted Hunter Biden. His attorneys and Hunter were going to agree to that via an information. It's a weird term, I get it. But nevertheless, those were two misdemeanor informations that doesn't require a grand jury, whereas a grand jury of his peers in Los Angeles County, probably, maybe somewhere from Riverside. I think Riverside covers some of the Central District. It's a huge district, largest population in the U.S. judicial district, even more than the SDNY. And remember, why does this matter? Well, first of all, Lowell should already be disbarred based on these proceedings way before this. Lowell has sued us in one jurisdiction and then written 5 different letters to the federal and state government. And it's not about us. I'm not saying this to say, oh, we're so tread upon. I'm saying that in each and every complaint, Robert, and each and every docket entry, Lowell lies. It's taken us 18 months for a district court judge to say, Lowell, dude, you're full of shit. Right. I mean, it's so bad that special counsel's office just put a motion in 48 hours ago. And I am a nerd. I do track the court listener updates on these cases religiously, maybe even with a capital R. They just put a motion in 48 hours ago that said Lowell lied during the trial in Delaware. What do I mean by that? He said in an opening argument, an attorney can reference what a witness is expected to say, right? The opening argument's like, I'm John Doe. You're going to hear from the police officer on this witness stand that there was blood on the shirt. But Lowell did that, and yet they never called the witnesses. So he said, you're going to hear from Jimmy Biden. And Jimmy Biden was not called, and the special counsel's office is just saying, hey, he can say that if Jimmy is called.
Right.
But you're bringing attention to evidence, and lawyers, or judges more particularly, are rightfully obsessed with what is said in front of a jury because they don't want to be overturned in a mistrial at the appellate level. So if you're going to say to a jury, you're going to hear from this witness, and that witness never shows. So what does this mean? The special counsel's office asked Scarsey to make an order, it was a motion in limine, to bar Lowell from saying anything to the jury about a witness that never shows. So what I'm trying to say is that this stuff is taught in 2L. Lowell, for $2,000 an hour in his cufflink shirts with Winston and Strawn behind his name or underneath his signature line, goes to Delaware and breaks rules that are so basic.
Right.
And the special counsel's office didn't realize this at the time. They have the benefit of transcripts now. So they're going through and say, holy crap, we should have brought this up in the trial because Jimmy never testified. And he told the jury that you're going to hear from Jimmy Biden, and he never showed. So I'm very passionate about this because I am fair. If these attorneys were honorable and were accurately representing reality, because reality is objective. You and I can't wake up tomorrow and become females. It is what it is. If these attorneys were accurately representing reality, Marco Polo would not go down hard on them. It's these guys are liars. Kevin Morris is a liar. Abbe Lowell is a liar. And I think you're excited too about this 4-pager because it's the first time in 18 months Noreika got a little bit annoyed with Lowell, more so with the staffer at Latham & Watkins who conned her clerk. Remember that? She had another order to show cause, but that was a paralegal at Latham & Watkins lying to her clerk. But this is the first time a judge has come by to the counsel and said, it's too much for me at this point. Lowell is a demon. And I think that if a pardon is to come, it's going to come the last week of August because this trial doesn't start till September 9th. It was scheduled for June 20th, and he got a continuance. Hunter didn't pay a thing. Kevin Morris paid him, and then they called it a loan, and Hunter hasn't paid anything back. He doesn't even have to start paying till October 2025.